Before I introduce our next speaker, I just want to make sure that you're aware of the fact that Wendy Templeton's paper is now available outside, so maybe if you haven't picked it up, you can pick it up when we break for lunch. I want to introduce our next two speakers who will bring us into the lunch hour. Pearl Schusheim, who is at my far right, is a tax partner with Ernst & Young and is the national leader of the personal financial counseling practice, which includes wealth management, succession, and estate planning and investment advisory services. Pearl, prior to joining Ernst & Young, has worked with leading law firms in Toronto, always in the tax planning and advice area. She's been involved in structuring and implementing diverse range of tax plans in the entrepreneurial and institutional context, and also advises extensively to the charitable and not-for-profit sector. Pearl was called to the bar in 1982, received her LLB from Osgoode Hall Law School. She also has an LLM in taxation and has authored many articles and has spoken in many seminars. Pearl is going to be talking to us about tax issues and estate planning, income splitting and trust distributions, a lot of activity in that area, and a lot of changes coming down the pike. Marni Whitaker is the other speaker at the podium here. Marni is with the law firm of Lang Mitchner. She's a partner there. She received her LLB from Osgoode Hall Law School in 1973 and was called to the bar in 1975. She's a member of a number of associations in the estate planning area, including the new one, STEP, Society of Trust and Estate Practitioners, and the International Bar Association. Marni has taught at the Bar Admission Course, thank you, and is a speaker at continuing legal education programs. Marni will be speaking to us about drafting payment terms in children's trusts, a very practical issue, and I think will be very helpful to all of us. I think, Pearl, you will be starting.
I was actually going to speak over there, but when I realized the monitor would be hanging over my head, I changed my mind. I thought it was a swift end to my speech. I hope you can all hear me. I've been asked to speak to you this morning on tax issues and estate planning, and specifically I'm going to deal with two topical but separate areas: income splitting after the 1999 budget and amendments proposed to the taxation of trusts. I'll try to avoid dealing in detail with the technical rules, and I'm going to emphasize concerns raised by these proposals, particularly for estate planners. I'd like to begin by dealing with the income splitting proposals first announced in the February 1999 budget and now contained in draft legislation which was released on September 10th. Now, income splitting is a common component of personal tax planning and often forms part of an estate plan, whether during a person's lifetime or after death. One logical consequence of our progressive tax rate structure is that taxpayers attempt to reduce their overall rate of tax by splitting income within a family unit and spreading that income among family members who would be paying tax at a lower rate. The government, of course, has tried to limit the increasingly creative income splitting arrangements that we've developed, and they've responded with a myriad of detailed rules, some very specific and others more general. I don't propose to review the detailed statutory rules, except to review some underlying principles. First of all, most of the specific attribution rules apply only so long as the transferor or lender of property is alive. Now, the kiddie tax, as the income splitting proposals are now commonly referred to, the kiddie tax departs from this principle, and I'll show you how that results. The tax consequences normally under the attribution rules are imposed on the transferor or lender of property, in other words, the person who's trying to split income away, and not the recipient of the income. And again, the income splitting proposals depart from this principle as well. Most of the attribution rules, except the corporate attribution rule, apply to actual income paid or payable to what I'll call an offensive person. And the kiddie tax is similar in that respect, so it's not a departure from that principle. The rules have only been applicable to the general attribution rules have only been applicable to income from property, and a statutory exception has applied to small business corporations. But the income splitting proposals that we now have will operate even if your arrangement otherwise avoids the corporate attribution rules and is consistent with tax policy up until now in that area. Clearly, the kiddie tax proposals arose in response to the proliferation of income splitting arrangements, many among professional firms, and some significant court decisions in favor of the taxpayer. And these decisions are reviewed in the paper, so I won't get into them now. Now, the income splitting tax is going to be calculated on split income at the top marginal federal rate of 29%. Would be nice if it was 25. And it's going to apply to certain types of income. Taxable dividends received from private corporations, whether those dividends are received directly or through an intermediary trust, and most often the minor will not hold the shares directly. It will apply to deemed shareholder benefits in respect of such corporations. It'll also apply to income received from a partnership or trust, where the income is earned from providing goods or services to or in support of a business carried on by a person related to the minor, a corporation of which such related person is a specified shareholder, and a professional corporation of which such a related person is a shareholder. Now, in computing that special 29% tax against this split income, there are no deductions or credits available other than the dividend tax credit and the foreign tax credit. But the split income will not also be subject to regular income tax and will be excluded from the various attribution rules. So that's some small mercy here. There are certain limited exceptions from these rules. First of all, the rules won't apply to minors who do not have a Canadian resident parent. Now, of course, I can't imagine that that's going to be a common situation. But thank you, that's one exception. Income from property acquired by minors on the death of a parent. That will be excluded as well. Again, not as common a situation as property inherited from other people. But where property is inherited from others, the income from that property will only be excluded where the minor has disabilities and is eligible to claim the disability tax credit, or is in full-time attendance at a post-secondary educational institution. Now, this is particularly where the proposals depart from the other attribution rules that we're familiar with, because the normal attribution rules cease to apply after the transferor or the lender dies. But here you have a situation where a minor can inherit property from someone other than the parent, and unless they're in one of these two particular categories, the split income tax will apply. And in this respect, I think it goes quite unfairly broadly. Also, when you look at full-time attendance at a post-secondary educational institution, you're looking at individuals who are very close to being adults, if they aren't already. So again, I don't think this is a very significant exception. Now, prior to the income splitting proposals, it was possible for a minor to receive about $23,000, $24,000 in taxable dividends from a private corporation without attracting any income tax. And the paper provides an example of how now those dividends, while they won't attract regular income tax, will attract this split income tax. And you can look at that in some detail later on. Now, there are a number of issues and what I call inequities presented by these proposals, and there have been a fair number of submissions to the government. In fact, our firm submitted extensive comments, and we were responded to fairly inadequately, I would say, unfortunately. And then the legislation came out, and that was the very clear response that our concerns were not going to be addressed. But one of the concerns are for private holding companies, where very commonly in an estate plan, you might hold investments through a holding company. And there are a variety of good reasons for doing that, non-tax reasons, I might add. But if you hold your investment in public companies through a private holding company, you'll be in a worse position than if you held the shares directly. So if a trust holds shares of the private holding company rather than these public investments directly, the dividends that are going to be distributed will be private company dividends and not public company share dividends. And so the income splitting tax will apply. And these are not arrangements that can be easily unwound without significant income tax consequences. But the government believes that there is some opportunity for manipulation at the private company level. And for that reason, and perhaps others that we're not aware of, are not prepared to rethink that aspect of the, or that consequence of the proposals. If you have an entrepreneurial minor who chooses to incorporate his or her business, they will be in a worse position than if they earn the business income directly. And in most situations, you're going to want to incorporate for liability reasons. But what's going to interest us, I think, most is the rules regarding bequests. And the exemption, as I've said, only applies to inherited property bequested by parents. It seems inappropriate to assume, to me, that there is an income splitting objective when you inherit property from another person, whether they're related to you or not, and you get interests in private corporations. The other specific attribution rules cease on the death of the transferor or lender, as I've said, and thus income from any property that has been inherited by a minor, in my view, should be accepted from these proposals as well. Okay, what planning opportunities do we have? Existing opportunities that still work, and I'm sure you're all fairly familiar with them. Dividends received from publicly listed shares would not be subject to these rules. Investment income that you earn through a private holding company, that is not earned, rather, through a private holding company, but in the case of a trust, a family trust, that's part of the estate plan, if that trust earns investment income directly, that can be paid or payable to minors without this split income tax being applied. Also, capital gains can still be split with minors without attracting attribution or this split income tax. Dividends from private companies can still be paid to spouses and to adult children that are in a lower income tax bracket, subject, of course, to the attribution rules when you're dealing with a spouse, because the attribution rules will continue to apply. Income from employment or personal services provided by the minor to the parent's business, but of course, the minor's services must be reasonable, or must, in fact, be contributed, and the compensation must be reasonable for those services. So, again, I'm not sure how many situations that would really cover. Management structures and other arrangements can still provide income splitting opportunities with spouses and adult children. Discretionary trusts are still going to be useful where the beneficiaries are adult children, and as I've said, there are other forms of investment income. The rules also don't appear to apply to dividends allocated from private companies to children who are disabled and in respect of whom the preferred beneficiary election is made, because the legislation refers to the deduction under 104 sub 13 and not to 104 sub 14, which is the preferred beneficiary election. And as I've said, the new rules do not apply to capital gains, and so there is still considerable opportunity to try to spread out capital gains among family members, usually through a trust, in order for them to claim the enhanced capital gains exemption available for qualified small business corporation shares. What are some alternatives? Property that is intended to be inherited by a minor, perhaps, from a relative other than a parent, could be retained in a testamentary trust and take advantage of the graduated rates in the trust. But you're going to have to give your trustees some flexibility here in the will. Business income received directly by a trust involved in carrying on a business, whether alone or in some kind of venture with another entity, would not be subject to the tax if the income resulted from the direct provision of goods and services to the public or some other unrelated party. Now, I'd like to talk about the trust proposals. In the brief time that I have left, I'd like to review some of the key changes to the taxation of trusts announced by the Department of Finance on December 23rd of last year. Now, as many of you can appreciate, in effective tax planning and in truly good comedy, timing is everything. But it was no laughing matter for tax advisors last year when the Department of Finance chose the very inopportune December 23rd to release a fairly significant set of amendments to the taxpayer migration rules and to the taxation of trusts. Many people were already on holiday, and others who couldn't get away were probably slaving away trying to finish tax plans to minimize the impact of the 21-year rule on January 1st, 1999. So we were hardly expecting a surprise package from the Minister of Finance, notwithstanding the environmentally correct brown wrapper. Now, I understand there are many other types of publications that come in brown wrappers, but this one was not nearly as entertaining. Anyhow, we all ran around trying to review the legislation to make sure it didn't impact us before the end of the year. And now that the dust has settled, we don't know what the final legislation will look like. We know that there have been, again, numerous submissions, and we do know that there will be wholesale changes. We also have heard that it is quite possible that the legislation will be released again at the very inopportune time at the end of December. So we have some warning now for that. But we can expect the major initiatives in the proposals will likely remain. Now, we've known about these changes to some extent since October of 1996, and that those 1996 proposals were motivated apparently by the Auditor General's criticism of two Revenue Canada taxation advance rulings permitting a Canadian trust to distribute property to non-resident beneficiaries on a tax-free basis. Of course, there was nothing wrong with it, but they didn't like it. Now, there was no suggestion, however, in the October proposals that there would be such wide-ranging amendments to the taxation rules applicable to trusts. The legislation that we've been looking at is very complex, very detailed, and far broader in scope than the original announcements. I'm not going to review these, but I should caution you that you will need to do that whenever you're dealing with trust taxation issues. You must be familiar with these proposals. I'd like to talk about some of the key changes. The definition of disposition has been greatly expanded and is now found in Section 248 rather than Section 54. Under the current definition of disposition, any transfer of property to a trust or any transfer of property of a trust to a beneficiary will be considered a disposition unless there is a transfer only of legal ownership without any change in beneficial ownership. There's been some uncertainty relating to the income tax treatment of transfers of property to bear and protective trusts, which are often used to minimize legal liability in a commercial context or for probate tax planning purposes. While the proposed new definition continues to treat a transfer of property to a trust as a disposition, it provides more explicit exceptions which are intended to formalize Revenue Canada's administrative policy relating to bear trusts. In the case of bear trusts, in the past, Revenue Canada ignored the trust for income tax purposes and considered the transferor to be the owner of the property for all purposes under the Act. For bear trusts, the relevant exclusion under the proposed legislation is for a transfer of property where there is a change of legal ownership without any change in beneficial ownership where certain conditions are met. It must be reasonable to consider that the trust acts as agent in respect of the property. In the case of a trust-to-trust transfer, each trust can reasonably be considered to act as an agent for the same beneficiary or group of beneficiaries. And the transfer is not from a person or a partnership to a non-resident trust, with certain exceptions. Clearly, the definition of disposition under the draft legislation will not apply where the transferee is an agent. This is consistent with Revenue Canada's previous stated administrative policy, and it's now clear that this will not constitute a disposition. But the exception in the draft legislation for certain intertrust transfers is new. That's an additional exception, and is apparently intended to facilitate these types of transfers. But as a practical matter, the requirement that the transferee, the recipient, held no property immediately before the transfer may be problematic, because in most cases, when you establish a trust, you must settle it with some form of property. And so if the property used to settle the trust constitutes property held immediately before the transfer, then this exception won't be available. So we're hoping that there will be some change to that exception. Let's talk about protective trusts. There has also been a great deal of uncertainty regarding the income tax treatment of transfers to protective trusts. Previously, Revenue Canada was of the view that a protective trust would arise when the trust deed contained certain terms, including the settlor being the sole beneficiary, the settlor entitled to as much income and gains as the settlor may have requested. The property of the trust would revert to the settlor upon the termination of the trust, and the trust would end on the death of the settlor beneficiary. Revenue Canada was previously of the view that a transfer of property to a protective trust would not constitute a disposition, and that the protective trust would be recognized both as a trust for income tax purposes and as the owner of the property for all purposes under the Act. Now, under the draft legislation, there's been a change in the characterization, but not in the result. It has not excluded a transfer to a protective trust from the definition of disposition, so we will have a disposition. But the tax consequences of a disposition will be governed by the provisions applicable to qualifying dispositions, and there's a whole separate set of rules for those. And so while a transfer to a protective trust will be a disposition, there won't be any adverse income tax consequences to the transferor as a result of this disposition, because it will be considered a qualifying one. But certain conditions have to be satisfied, and these conditions are mainly expressed in the negative, which is a common tax drafting practice. There has to be a change in legal ownership without a change in beneficial ownership. The disposition cannot be made by a trust to a beneficiary. It's not that kind of disposition that we're covering here. The disposition is neither by a Canadian resident or non-resident trust, nor a transfer of taxable Canadian property from a non-resident person who had been resident in Canada in any of the preceding 10 years. The disposition is not by a partnership to a non-resident trust. The disposition is not by a person or partnership to a trust where the person or partnership has the power to appoint beneficiaries. And finally, the disposition is not by an individual to a particular type of trusts described in certain parts of the definition of trust under the Income Tax Act. So we have to figure out what we're actually left with here. But clearly, when you have a transfer to a bare trust, it won't be a disposition. But if you have a transfer to a protective trust, it will be, but without any adverse income tax consequences. And that has repercussions. I emphasize that because that has repercussions elsewhere under the Act. So for example, if you're dealing with stock options, you may find that all you need to have is a disposition of the option or the shares in order for the benefit to be triggered. Although there won't be any income tax consequences on the disposition, the inclusion of the employment benefit might be triggered. And there are other situations under the Act where the concept of having had a disposition may become relevant. Now, a word on revocable living trusts. I'm sorry to speak so quickly, but I have a lot to cover here. Revocable living trusts are often used in the context of probate planning. Under a typical revocable trust, the settlor is also the trustee and the sole income and capital beneficiary during the settlor's lifetime. Income and capital interests will devolve on other beneficiaries after the settlor's death. At one time, Revenue Canada had taken the view that a transfer of property to such a revocable living trust that was resident in Canada would not be considered a disposition because the settlor would have retained the beneficial ownership of the property. But Revenue Canada has changed its view and now considers that such a transfer should be recognized as occurring at fair market value for income tax purposes. So under the draft legislation, a transfer to a revocable living trust should be considered a disposition, but it will not fit within the exceptions set out in the proposed definition of disposition, assuming that the trustee is not acting as an agent. It may, however, be a qualifying disposition, and you'll have to, in each case, look at those negative conditions to determine whether or not you can get out of the negative tax consequences by having a qualifying disposition. I'd like now to turn briefly to trust distributions. Now, currently, a trust can distribute certain kinds of property, most notably taxable Canadian property, on a tax-deferred basis to non-resident beneficiaries, as well as Canadian resident beneficiaries, but to non-resident beneficiaries in satisfaction of their capital interests in the trust. Now, these changes don't affect Canadian resident beneficiaries, but they affect non-resident beneficiaries, and certainly in our practice, we find increasingly that people have moved to the US or elsewhere, and you have trusts which have non-resident beneficiaries. So it's always really important to get all the facts from your client. The draft legislation will provides, with few exceptions, that a Canadian resident trust, that where a Canadian resident trust distributes taxable Canadian property to a non-resident beneficiary after October 1st, 1996, so it goes back to the original announcement, in satisfaction of the beneficiary's capital interest, it will be considered to have disposed of the property. Now, there are exceptions provided for example, Canadian real estate and other types of property that are specifically excluded from the taxpayer migration proposal. So there's a list under 128.4, sub 4, of specific property to which the departure tax rules will not apply. And that's the same list that applies here, which can be distributed on a tax-deferred basis to a non-resident. But it's a pretty narrow list. It represents these rules represent a significant expansion of the current rules applicable to the taxation of distributions to non-resident beneficiaries, and will now trigger capital gains, for example, when private company shares are distributed to a non-resident beneficiary. Now, it's important to note that the new rule only applies to Canadian resident trusts, while the current rule applies to non-resident trusts as well. So a non-resident trust could roll out property to a non-resident of Canada, and then subsequently tax will be imposed if it's taxable Canadian property under our domestic and treaty system. One of the relieving changes applies to the current rollout of property to a beneficiary in satisfaction of all or part of the beneficiary's capital interest. Under the draft legislation, the trustees of a trust will be permitted to elect out of the automatic rollout for distributions made again after October 1st, 1996. And as a result of this election, a distribution of trust property can give rise to proceeds that are equal to or the greater of fair market value or cost. Now, while losses may not be triggered on such a transfer, the election can facilitate the use of losses that have been accumulated in the trust, because as you know, you cannot flow losses out of a trust. If you have realized losses in a trust, they will stay in the trust and they have to be used to offset other income from the trust. So you might want to elect out of the rollover to trigger some gain to use up losses that would otherwise expire and not be available. The relief is blunt, though, because there's no flexibility as to the amount of the gain that can be triggered in this way, and full fair market value proceeds will be considered to have been realized. So there's no election mechanism. You're either in or you're out, but you can elect on a property-by-property basis. So you'll look at the relative values and appreciation in the various properties, and you will judiciously choose which properties to elect out of here. Now, one of the sleepers in the proposed amendments is the inclusion in the definition of arm's length of a specific provision dealing with trusts now. Up until now, Revenue Canada's position was that it was a question of fact whether or not a settlor or a beneficiary dealt at arm's length with a trust. The draft legislation proposes an extremely broad amendment which would result in a taxpayer and a trust being deemed not to deal at arm's length where the taxpayer or any person not dealing at arm's length with the taxpayer is beneficially interested in the trust. So even if this person has no influence over the trustees, if they're related to or don't deal at arm's length with the beneficiary, they're considered not to deal at arm's length with the trust. So it's possible that if a taxpayer is one of many beneficiaries under a discretionary trust, or doesn't deal at arm's length with such a beneficiary, has no connection, as I said, or influence, they'd nevertheless be considered to not deal at arm's length. And this is a very broad rule that goes well beyond any factual arm's length test. We understand from informal discussions that the scope of this rule may be limited to the commercial trust context and not personal trusts. But I don't have any kind of official statement on that, so we'll have to wait and see, and I would advise you to look at least to that amendment because it has very significant implications. Other changes are summarized in the paper, and time really doesn't permit me to review them in detail, but I'd like to simply close by saying that if you're advising a beneficiary or a trustee of either a Canadian resident or a foreign trust that holds Canadian property, it's going to be essential to become familiar with these rules and understand how they may affect your client and your arrangements. Thank you.
Good morning. I'm going to speak about drafting payment terms in children's trusts, and I will try to get you out in reasonable time for lunch. My paper addresses the issues which should be considered in drafting the terms of payment provisions, and it's really a follow-up to the paper I presented at a September 15 Law Society program dealing with a practitioner's guide to using trusts effectively. I start with the assumption that it is the drafter of the will or the trust who must ensure that the language used conveys the intentions of the settlor or testator. A client may know at what age a minor beneficiary should receive capital, but he or she is unlikely to have considered in any detail how money is to be used for the beneficiary until the capital is paid out. When drafting, lawyers must be aware that trustees will look to the wording of the payment provision in exercising their discretion to make or refuse payments. There are likely to be fewer questions about what can be paid out if only a narrow range of payments is permitted and specifically described. However, in many cases, this is not desirable. Testators and settlors often don't have specific purposes in mind and instead want the trustees to be able to make any payment which could benefit the minor. If some expenses can be predicted, they should be referred to so that it is clear that the payments can be made. This is particularly the case if the amount in trust is small. For example, if a grandparent creates a testamentary trust of, say, $15,000 for a grandchild, and the grandparent intends that it be used for educational expenses and isn't concerned that the entire amount will be exhausted in paying for 1 or 2 years of university, the clause should permit the trustees to use it all in this way. Starting on page 2 of my paper, I list several issues which can create problems in payment provisions for minors. I would ask you all at this point to take your pens and renumber the paragraphs. So there's only one paragraph 2 and one paragraph 3. Cutting and pasting doesn't always work. I'll just go through some of these issues. The first one, how much income should be paid out? The settlor must consider what income a minor may need. A 2-year-old obviously will require a lot less than a teenager. But if the trust fund will be held until the beneficiary is 25 or 30, the payment provision must be broad enough to accommodate those ages and all ages in between. Should excess income be accumulated or paid to others? Are there any other beneficiaries who should receive any income which is not paid out to the principal beneficiary? A typical provision would be to pay any excess income to the children of a beneficiary who may be in his 20s or 30s, but has not yet become entitled to all of the capital. That would permit some income splitting. The second issue is what types of payments can be made. Does the testator intend that the income will be the primary source of support for the beneficiary, as would be the case if the trust were for the children of a single parent? Or is it intended that the trust will be used only to pay for extras, and that the bulk of the principal and accumulated income will be turned over to the beneficiary at the appropriate age? The fourth point, does the power of maintenance extend to adult beneficiaries? There are cases which suggest that maintenance may end when a beneficiary attains the age of majority, unless the settlor or testator provides that it is to continue. Accordingly, if it is intended that the capital is to be held until a beneficiary attains the age of, say, 30 years, and that the income can be used to pay for the beneficiary's necessaries of life, that should be clear in the provision. The fifth issue, may accumulated income of past years be used for current maintenance? If a fund is set up for a minor beneficiary, and not all of the income is needed for the beneficiary when he or she is young, and the excess is accumulated, can that excess be used for the beneficiary in later years when his or her income needs are greater? Can you make that capital back into income? In order to do this, the trust provision would have to specifically permit accumulated income to be used in this way. If it did not, the excess income would become capital and could only be paid out under a power to encroach. The seventh issue is how is the power of maintenance to be paired with the legal duty of the minor's parents or grandparents, parent or parents, to support the minor? Is the income from the trust to be used only for items that the parent is unable to supply? The answer would probably depend on which of three general categories the trust fell into. In the first category, the trust would have been set up by a person who has no legal obligation to support the minor, for example, a grandparent or aunt. Testators in this category would probably prefer not to have the trust used to pay for basic necessities unless they knew there were financial difficulties in the family. In the second category, the trust would have been set up by a parent for a beneficiary who would still have one surviving parent. Testators in these circumstances would probably want the surviving parent to have very broad powers to use the income to replace the income which the deceased parent would have provided for the beneficiary's expenses. Unless, and this is really at the opposite end of the category, the testator and the surviving parent are divorced, and the testator would want to control the expenditures so that the funds could not be spent for the surviving parent's benefit. Obviously, the two scenarios call for very different drafting. In the third category, the trust would have been set up by the surviving parents or both parents so that the beneficiary is left only with guardians or adoptive parents. In these circumstances, I think it would be appropriate for the trustees to have a very wide power to use the income for any expense which could benefit the minor, so that the guardians or even adoptive parents would not be penalized financially by taking on the burden of raising an additional child. Issue 8, at what age should the beneficiary be entitled to receive the capital? Parents vary widely on that question. There's the story of the elderly man who visited his lawyer and wanted to change the age at which his children were to inherit from 60 to 65 because he hoped they'd be mature by then. Generally, in my experience, parents decrease the age at which their children are to take as the children mature. Most parents with children of 30 or 35 no longer want their children to wait until they're 40 before receiving capital. Conventional wisdom says capital should be paid out in 2 or 3 stages, so that if a child spends the first installment foolishly, he may be more careful with the next installment. One variation I don't agree with is to pay the capital out over 10 years. I think the beneficiaries receiving payments that way would be likely to confuse them with income and simply spend each one as it comes in until they stop. Issue 9, can money be made available to the guardian or adoptive parents of the minor beneficiary to help with the costs of raising the child? The children's lawyer takes the position that adoptive parents, in particular, have assumed the burden of looking after the minor beneficiary, and that amounts can be spent from the minor's trust only if the expense is for the benefit of the minor, which is quite understandable, and if the expense is beyond the ability of the adoptive parents to pay. If testators wish to alleviate the burden of future adoptive parents, the trust provisions must make this clear. In addition to broad powers to make payments for minors and directions to make fixed payments to guardians or adoptive parents, a will can also provide that trustees may make loans to such persons, for example, to assist them to purchase a larger home or renovate their home to accommodate the children. Issue 15, should other sources of income be available to the minor be considered? If a minor beneficiary is the named beneficiary under several family trusts, or if he or she is a millionaire website designer, should the trustees be able to take income from these other sources into account? In the absence of specific wording, the cases go both ways on this issue. If it matters to the testator or settlor, add in some clarifying wording. The last issue, what different levels of payments are permitted by the use of the word maintenance rather than comfort, education rather than advancement, well-being rather than benefit? Does support cover all the necessaries of life and make the parent's legal obligations irrelevant? As my comments on the precedents later in the paper indicate, different words imply different measures of amounts to be paid, with support and maintenance probably having the narrowest meaning and benefit the broadest. I think in drafting all of these provisions dealing with minors, you have to imagine yourself in the position of the trustee dealing with the estate or trust, and see if you can determine from the document how to deal with the assets. If you can't see the game plan from the documents, the trust agreement or will needs revising. I wanted to conclude with some comments on letters of wishes or memoranda to trustees. As my paper indicates, the contents of such documents are precatory only and do not give binding instructions to the trustees. On the other hand, letters of wishes can provide comfort to trustees if they clarify the scope of the trustees' discretion or explain family circumstances which might not be apparent to trustees. The question then arises whether such documents are confidential or if the trustees would have to disclose them to a beneficiary. Based on the House of Lords decision in O'Rourke versus Derbyshire, reported in 1920, All ER Rep 1, if documents belong to the executors as executors, the beneficiary has a proprietary right to inspect the documents. The English Court of Appeal decision in Re Londonderry Settlement, reported in 1964, 3 All ER 855, dealt with what documents had to be released to a beneficiary. The court held that since the trustees were not obliged to disclose their reasons for exercising their discretionary power, they did not have to disclose to the beneficiary the agenda or minutes of their meetings or documents prepared for trustees' meetings. But the court reiterated the principle that trust documents in the possession of the trustees are the property of the beneficiaries and are open to them to inspect. Accordingly, it is my view that a letter of wishes or a memorandum to trustees would form part of the trust documents and would have to be disclosed to a beneficiary. My paper concludes with a review of some standard precedent clauses and an analysis of the extent to which the issues raised earlier in my paper have been addressed in each. I think it'd be very boring for you to listen to me read precedent clauses, so I'll stop there, and I thank you for your attention.
Thank you very much for your kind attention this morning to all our speakers. Give you an hour and a half for lunch. If you would be back by 1:30, we'll start again. And it's a rather packed afternoon. Thank you very much.